This is week 2, module 3, and we're going to cover the requirements of state statutes that you should be familiar with. Again, this is going to vary by state. We can't tell you what all of the states require, but we can give you some general rules. And I might also note that these are statutes that can be negated by will provisions, and in many cases I recommend, as your attorney will also recommend, that you modify the state requirements or do what you feel is important. The ones that are covered in your textbook that I think are very important you should be aware of is, first of all, the abatement statute, which does affect, again, the assets that are going to the beneficiaries. Redemption statutes, which also affect what goes to the beneficiaries. The anti-lapse statute, the divorce or annulment statute, the simultaneous death statute, and the tax apportionment statutes. It's sort of like a checklist we use when we're looking at wills to make sure they're in there, and if the lawyer hasn't covered it, we want to make sure the client understands what the result of it is. Again, we don't tell them what to do, but we listen to what they want, and if it's not consistent with what they're showing in the will, then we will go and talk to the lawyer directly. Testator wills have certain requirements. First of all, there's a minimum age. That age is again determined by state law. It's very similar in all states is testamentary capacity. Does this person have the capacity to be able to understand what its assets are, who are the beneficiaries of those assets, and the fact that the will is transferring the assets. And there are obviously cases where people aren't able to do that and they are not qualified to do a will. That could be caused by dyslexia, it could be caused by lack of mental capability, it could be caused by a lack of maturity, such as being too young. I might note that most states say that if a person is married and they're under the minimum age for the state, by being married they're allowed to make a will. And also we have situations where courts release the child from the control of the parents and give them maturity and the rights of majority, even though they are under the age, and those people also are allowed to have a will. It's a process document, and that's the best way to describe a will. It's a process. You do steps A, B, C, D, and when you're done doing steps A, B, C, D, it comes out as a valid will. I might note that you're going to find wills in stationery stores, you're going to see them on the internet, and I would say in all cases it's a good idea not to just take these documents that are for $10 in the stationery store or on the internet, but have a lawyer prepare it. Again, we want it unique for the particular needs of your client. Now, if the client doesn't have anything, they've got personal assets worth a couple of $100 and maybe an old junker car, they're behind in the rent, and they have a lot of credit card debts, let's face it, anything is probably better than that. They certainly can't afford a lawyer for it, but that becomes the exception. You, as a financial planner, are not going to run into those people very often unless you're doing pro bono work. The types of clients you have should be able to have the ability to afford to have the will prepared by your lawyer so that it meets the procedures of your state, which means if you move from your client moves from one state to another, they really have to consider about having a new will reviewed or to have their will reviewed by an attorney in the new state they're moving to, because it's the state that you're domiciled on at death that's going to determine what the will is and how it's to be interpreted. Many times, if you do get a process will in a stationery store online, you'll see it's a fill-in-the-blank form, and maybe even you'll see it at a legal self-help center. Again, for the size of the assets of people who go to financial planners, I would say it is going to be not worth doing, and it's probably a disservice to the client even discussing it with them. Now, you're going to say, okay, what dollar value do people go to see financial plans? Well, that depends where you locate. For example, if you're a $100,000 income in New York City, quite honestly, you may not be able to afford an attorney. Where if you're in Georgia or Mississippi, 50 or 60,000 may be more than substantial for seeing a financial planner and using an attorney. So it depends where you are as the economic being of people being able to afford financial planners. And you can find that out from your local financial planning association, or talking to maybe the lawyers in your area or the CPAs in your area as to who would be the type of people you would expect to see as clients. I many times see people saying, who are going into financial planning, saying, well, I want to service the middle class. And for me, the middle class are people who are in California from 30 to 70,000 a year. That, again, is subjective in my mind, because if I look at the state of California and the federal government, says the person who's earning 30,000 a year are really in poverty. But I have seen many people who are earning 30,000 a year who live reasonably well off. Again, not wealthy. But the question is, California, can financial planners service the 30 to 70,000 a year people? And I'm going to say that you're not going to make any money if you do that. I've seen retired financial planners, retired registered reps who service these people, but as far as trying to make an income from them, you're not. So you really have to check around and see who it is. And again, that's why I say you probably, your clients who come to you should not be even thinking about using a will that's found on a stationery store or legal self-help center, and worst of all, just on the internet. There's three types of wills we have. Again, I'm not going to spend a lot of time on this, as it is covered very well in the textbook. There's the witness will, which is by far the most common, the holographic will that's recognized in some states, and the non-cumulative or deathbed will that's recognized in some cases. I would say for the practical matter, you're probably not going to run in any cases other than the witness will. And that varies as to who has to be witnesses by state. The execution of wills requires the testator, and the name for a female testator is a testatrix. Again, that's the person who's preparing the will, and when they die, they become the decedent. There's also witnesses. Some states have 2 witnesses, some have 3. Some states allow for notary public. Again, you have to look at the particular requirements of your state as to who is required on the wills. It's going to vary. Types of wills. I've seen 5, 6 different types of wills. For the practical matter, there's 3 types that I like to talk about. One is the simple will. That's the typical will. I give my assets to my beneficiaries, including charities, and it's a will written by an individual. If you go on the information for this week, you're going to see the Elvis Presley will, and that is a good example, excellent example actually, of a simple will. We have reciprocal wills. I give all my assets to you, and you give all your assets to me. The disadvantage of that will to me is because of the contractual relationship. Once you make a reciprocal will, you cannot change a will without the permission of the other person having the reciprocal will. This is typically between husband and wife. I give everything to my wife, and my will, she gives everything to me. Or it might be siblings giving it to each other. Again, this is not the best way, but people do it. It's something you can do. And then we have mutual wills, and I had one instance of this where there were 3 brothers who were very successful. None of them were married and earning very good income. They had a younger sister who was quite a bit younger than them. She was probably 15 years younger than the youngest of the 3 brothers, who married extremely young, had 3 children real fast, and her husband disappeared. So they had in their wills that when they died, that their assets would go to their sister. So all 3 of the brothers, since they had no other relatives, had their wills again made it out to the sister, all three mutual wills benefit that sister. Where I got involved, quite honestly, is one of the brothers late in life got married and wanted to change the wills. And that's when I said, see an attorney. Clause recovered by wills, again, this level you need to know for your job as a financial planner are called, in the textbook. There's an introductory clause, which is a fairly standard, being my last will and testament, etc. The family statement, the disposition assets, who handles the death tax, and the death tax is the estate taxes, inheritance taxes that occur, and I also think that most lawyers today include income in respect to the decedent, which we'll talk about later in the course. The residual clause, which is always a good clause for any will or trust. The appointments of the executor or administrator, whatever term is being used in that particular estate. The signature, the attestation by the witnesses, and a self-proving clause. So these are the clauses that you're going to run into in a will. Again, if the lawyer doesn't have it in, it might be because of the state law or some court cases in your state. I would not question the lawyers because they are, especially if they're an estate attorney, are very knowledgeable of what really is required by your state. And with that, this is the end of our module, and I suggest you go take a look at Module 4 at your earliest convenience.